Whether you have an employment, criminal, family, corporate, or personal injury matter, legal issues can be puzzling. The lawyers at Devry, Smith & Frank make all the pieces fit together.
So my topic touches back on the issue of privacy that Christopher mentioned a bit earlier on. So with the increasing usage of the internet as well as different electronic devices, it becomes increasingly important that employers and employees understand what is acceptable, what is not acceptable. Chris talked a little bit about postings, general rules, think before you post. Now, what happens when an employee doesn't post and it's on something as simple as a workplace issued computer or BlackBerry or iPhone, which as positions get more senior and employers want their employees to be on call pretty much all the time, they do issue these types of equipment. And what if they don't necessarily put things out in the public forum, but they keep things on these hard drives or on the network servers and expect that there may be some element of privacy? What is that reasonable expectation? And this new case, R.V. Cole, although it talks about, it's a criminal case, has some implications for civil matters as well. So the basic facts of this case, I'm just telling you just so that you have the background, was that it was an Ontario high school teacher. This was in October 2012, so quite recent case. He was provided with a laptop specifically for the purposes of work. The policy did allow for personal use, which he did. This teacher in particular, what's interesting was that he had the administrative rights because he was teaching a technology course and he was also in charge of the program for the students. He had the ability to go into students' email accounts and see what they're doing, like as a form of policing. And he did that, and it turns out that in a routine maintenance check by another employee of the school board, he discovered that there was some improper use. What happened was that the teacher went into a student's account, found some new pictures and downloaded them into the hard drive. And he also downloaded other things. I know pornography is a touchy topic here and there, but some people download not just improper pictures, but other things, personal, Word files that they're using for home purposes. Those things are all covered in what an employee puts onto a computer that he thinks or she thinks that they have exclusive use, because they may put passwords on them that the administrator may not necessarily know. I guess the case talks about what should be expected. So what the employer did in this case, because there was improper use, they downloaded these pictures. First they confiscated the laptop, they downloaded the pictures onto CDs, and they handed it over to the police, which from just the face of the facts seems like the right thing to do because the employee acted improperly. Now the issues that the court talks about was, did the employee have a reasonable expectation of privacy? Was there a privacy breach? And if the privacy was breached, should that evidence be admissible? Now remember, this was a criminal case, but it can apply in terms of evidence in general and what would be used in civil lawsuits or arbitrations. So the short answer is that yes, the court, and let's remember this is the Supreme Court, so it's the highest level of court, said that there is a reasonable expectation, especially in situations where personal use is permitted or reasonably expected. In this case, the policy actually said they could do personal use, but for any device, especially BlackBerry, iPhone, laptop, that you're giving to your employee, you're going to expect them to use it, off hours, not just for work, probably for personal reasons as well. Now, the situation with the warrantless search was because the employer thought that the employer did have the right to take back the laptop because the employer gave them the laptop, and it's not unusual to think that you have the right to that specific piece of equipment. But the issue came up because they gave it over to the police, which don't necessarily have the same type of rights. So the police didn't subsequently take that extra step and get the warrant, which is what the court talks about, because technically the police are the ones who violated that Section 8, which says that everybody has a right to be secure against unreasonable search and seizure. So it was a technicality. Now, with respect to whether or not that evidence should be admissible, it went through the trial stage of the Superior Court, which said no. And then it got appealed, and someone said, yeah, maybe I'll let it in. Then the Court of Appeal came back and said, no, exclude. But the Supreme Court said that even though it was illegally obtained in a technical sense, this should be admitted in a new trial because the breach of the charter wasn't egregious enough, because the officer acted in good faith, thought they had the right because they got it from the employer, and technically if they wanted to take the steps to do the search warrant, they could have done that. Now, what we care about as employers is what did they do right. So they had a written policy with respect to this particular usage of computer equipment and how it should be handled. And in their policy, they had specified that all the data and messages generated on these types of equipment could be considered property of the school. So that's a good thing. They also had a separate section with respect to the fact that the administrative team, not necessarily the teacher in question, could legally open private email if it was necessary for the ongoing health of the system or if inappropriate use was suspected. So they're trying to cover all their bases. They also had a general acceptable use policy that was directed towards the students that said that emails and material saved on hard drives and network servers may be monitored. But to do the extra step, they reminded them on an annual basis that the policy applied to everyone, students as well as the teachers. Now the problem is, the court said that's still not enough. You can put in all these terms in your policies and practices, and while it may diminish the reasonable expectation of privacy with regards to personal information, it does not eliminate it, period. You have to consider the totality of the circumstances in order to determine whether or not privacy is a reasonable expectation. So the totality of circumstances test is set out in 4 different steps that the court talks about. So first you have to examine what the subject matter of the search was. So in this particular Cole case, the subject matter was the photographs that were downloaded. Now B and C kind of go hand in hand, and in determining whether or not the employee has a direct interest. They do. That's usually a given since they're the ones who obtained that information. And then whether or not they had a subjective expectation of privacy. And because it was a laptop that was given to them, that they used primarily, that wasn't something shared with other employees, they determined that the subjective expectation was there. Now the problem that the school board had with respect to the last point of the test was whether or not it was objectively reasonable. Now the court found that because they allowed personal use in their policy, the expectation of reasonable privacy had to be balanced, because in essence their policy and their practice weren't exactly in sync. You can't say, I expect you to divulge all the information that are on these things, but I'm going to let you to use the personal, use it for your personal uses. So what you have to learn from Cole as an employer is that the reasonable expectation of privacy doesn't just cover computers, although the equipment in this case is with respect to computers. It may go further to do iPhones and BlackBerries, which are much more common in today's workplace environment. Now, the ownership of these products, being usually the employer because they pay for these items, doesn't necessarily give the privacy interest to the employer. The employee still has that and can survive ownership of whoever owns it. If you try to set a policy or procedure with respect to limiting someone's reasonable expectation of privacy, while these policies may be taken into account, they won't necessarily eliminate, and the court will try to balance it. And if you're going to say don't use things for personally, you should either explicitly say it and then don't allow them to. So you can't put a policy that says, I don't want you to use it for personal, but then when your employees are using it for personal use, you don't do anything about it. So the employer should revisit their policy and make sure that it's very clear. The case talks about certain examples of how to make something clearer. For example, in your policy and procedure manual, you can say for what particular purposes you may be monitoring or going into this information, like to analyze usage and how you're going to go about doing it, maybe on a monthly basis. Your IT guy will go in and look at traffic. If you put that out in your policy, even though it may not reduce the claims necessarily, like we had said, for courts to have something in place in writing often puts the employer in a better position when litigation happens. And the important lesson from Cole is that if the reasonable expectation of privacy is violated, some of that information may be excluded as evidence. So if you wanted to use something that you violated their reasonable expectation of privacy, and you wanted to use that later on in a suit to defend yourself, that's still up in the air whether or not you'll be able to use that. Now, with respect to this tort of invasion of privacy that Chris talked about briefly, the Jones and Tsige case, which I apologize, it's not on the slide, but that case was a case that was determined about 10 months earlier than the Cole case. So that was a January 2012 case. And the facts of that case are with respect to two employees at a bank. They both worked at BMO. And it was discovered that one employee, Tsige, was the, I guess, common law wife or girlfriend of Jones's former husband. So what Tsige was doing was she would go into the bank's database and look at Jones's banking records. And her explanation was that she did it for the purposes of knowing where her boyfriend was spending money and if he was using it for the purposes of support payments to his ex-wife. Now, to establish the court, what's important for that Jones and Tsige case was that this was the first appellate court decision that made a definitive statement with respect to an invasion of privacy. Before this case, other superior court judges had tried to lump together invasion of privacy with other different torts, like nuisance or trespass. And people have, judges did find that damages could exist, but they didn't specifically say it was for invasion of privacy. So this Jones and Tsige case was important in the sense that an appellate court judge said this tort could essentially exist. To establish the case for invasion of privacy, the plaintiff had to show several factors. First, that the defendant acted intentionally. So in the situation of the Tsige case, she did. She actively went into the plaintiff's bank account records for a number of times. I think in particular it was 174 times. To say that you didn't do that intentionally is difficult. So now the second factor is whether or not the defendant actually invaded the plaintiff's private affairs. And something like financial records is very clearly something that is private, because you don't necessarily want everybody knowing how much you make, how much money you have, and the fact that she used her position to do that wasn't favorable in the court's eyes. Now, whether or not a reasonable person, reasonable is a very funny word, I guess, is the way the court see it, because reasonable is different for each person, but the objective thing is whether someone, not you, would regard that evasion as highly offensive, and someone saying that, someone looking at your bank records could be offensive. Now, the Jones and Tsige case also set out the principles that that unless there's pecuniary damages, as in you suffered some sort of loss or monetary loss, the court has said they won't grant damages too high. The limit in that case, she claimed for $90,000, she ended up getting 10. But the court said, usually in these types of circumstances, we would grant up to a maximum of 20. Now, as an employer, $20,000 doesn't sound like a lot in terms of damages, but you have to think about in terms of litigation and costs. Are you going to be spending much more than that in terms of defending an action or prosecuting one if you want to claim against a past employee? Now, the case is also important because with respect to privacy legislation, there's PIPEDA, there's Personal Health Information Act, there's the Municipal Freedom of Information and Protection of Privacy Act, and the Consumer Reporting Act. The court said that while there isn't anything particular in common law before this, because this case became the common law, the reason why they didn't want to rely specifically on legislation is that the legislation doesn't necessarily grant the ability to award damages. So by allowing this plaintiff to successfully get damages, although it was only $10,000, the court has essentially put out this new tort of evasion of privacy. And even though the amounts are nominal in most cases, sometimes they've left it open by putting in a statement that say exceptional circumstances lead to exceptional rewards. So that basically means that an employer, when you're thinking in terms of Cole and Tsige, these two cases, you have to keep in mind that for Cole, you have to be wary of what's the type of terms in your policies and procedures to make sure that you are as transparent as you possibly can be in terms of if you want to access that kind of information that you think you're entitled to, because now the Supreme Court has said actually the employee has a reasonable expectation of privacy, and that in order to get that stuff, they didn't specifically say in that case what they would rule in terms of monitoring. So as an employer, for monitoring in general your employees, I guess materials on their equipment, that's still kind of up in the air. But if you actually wanted to use that against them and just take that information, they said that there is a reasonable expectation of privacy. And because of this new invasion of privacy, it leaves the employer slightly exposed to employee claims for privacy infringements. So you have to be careful in a sense that if you're going to use that information or try to obtain that information, it should be for proper purposes, and you should be able to justify it. There should be some sort of reasonable suspicion, and that if you are going to go into that, you should at least have it somewhere in your policy that gives you the right to do that, or at least the thought right to do that. And if the employee wants to take you to court, you can say, it says it in your policy, I'm allowed to monitor you for X, Y, and Z, and that's why we've done that, and FYI, look what we found. So basically, what you have to take back from these two cases is that even though you can't necessarily limit an employee from making whatever claim that they can or want to, because there's tons of frivolous claims out there, the best way to protect yourself as an employer is to understand these two cases and try to make your information as detailed as you can out there for the purposes of your employee.